Edmonton.
Thank you, Madam Speaker. It is an honor to rise in strong support for Bill C-268. This is a straightforward piece of legislation, the objective of which is extremely important, namely to ensure that the charter rights of health professionals who conscientiously object to participating in medical assistance in dying or MAID are protected. Charter rights that include freedom of religion and freedom of conscience, those rights being not any rights, but fundamental freedoms guaranteed under the Charter. And for that, I want to commend my colleague, the Honourable Member for Carleton Trail Eagle Creek, for her steadfast leadership in bringing forward this timely bill and targeted bill to address an issue of charter infringements on healthcare professionals. And I would also acknowledge my former colleagues Mark Warwa and David Anderson for their leadership in bringing similar pieces of legislation forward in previous parliaments. Contrary to the assertion of the Parliamentary Secretary to the Minister of Justice, the infringement of charter rights of health professionals is not a hypothetical. It is real, and it is happening in Canada and has been happening really since the Supreme Court of Canada struck down the blanket criminal code prohibition against physician-assisted death in the Carter decision. Many health professionals have been pressured or coerced into participating in MAID, notwithstanding their conscientious objection to do so. We heard at the Justice Committee on Bill C-7 many witnesses who came forward and spoke about serious concerns about coercion and pressure and the need for clarity in the law and a national standard set. And that is precisely what this legislation seeks to do by amending the criminal code to see that no one will lawfully be able to coerce or pressure a healthcare professional for the purpose of compelling them to participate in MAID or to refuse to hire or terminate one's employment on the basis of a healthcare professional objecting to MAID. Madam Speaker, the Parliamentary Secretary to the Minister of Justice in his speech made reference to Bill C-14. It's a piece of legislation that I'm very familiar with because I sat on the Special Joint Committee leading up to Bill C-14, and I sat on the Justice Committee when Bill C-14 was studied. And at that time, there was much discussion around protecting conscience rights. And he is correct that the preamble of the bill was amended to include an expressed recognition of conscience rights. And he is further correct to note that at sub 9, section 241.2 of the Criminal Code, there is a for greater certainty clause that simply provides that no one shall be compelled to participate in MAID. And so in that broad sense, there was an expressed intention of Parliament to protect healthcare professionals. However, what is missing, Madam Speaker, is teeth. There is no enforceability mechanism provided for in the legislation. That was something that I saw as a problem at the time, and it has borne out to be so. And that is precisely what this bill seeks to do, is to fill that very real void. Now, the Parliamentary Secretary to the Minister of Justice, as well as my colleague, the member for Esquimalt Saanich Sooke, spoke at varying lengths about the Ontario Court of Appeal decision in Christian Medical and Dental Society of Canada versus the College of Physicians and Surgeons of Ontario, and the issue of access, that somehow this bill would interfere or undermine access to medical assistance in dying. Well, I say two things to those who raise the issue of access. Manitoba passed Bill 34, which provides for conscience protections, not dissimilar to what this bill proposes. There has not been one instance that has been brought forward where access has prevented a willing patient from accessing Made in that province, a law that has been on the books for more than 4 years. And with respect to the Ontario Court of Appeal decision, although the court in its analysis looked at hypothetical issues around access, the court actually incorporated the divisional court's finding into its ruling, wherein the divisional court and incorporated into the Court of Appeals ruling said on the question of physicians who object on the basis of conscience, quote, "There was no direct evidence that access to health care is a problem caused by physicians' religious objections to providing care," close quote. So there you have it, Madam Speaker, right from the Ontario Court of Appeal, that the issue of access, when it came to providing direct evidence, simply wasn't there. And at the Justice Committee, when we studied Bill C-7, it wasn't there either. Now, Madam Speaker, when we talk about the Carter decision, I think it is important to emphasize that it is predicated upon two things. Number one, that there be a willing patient, but number two, and equally important, that there be a willing physician. And yet, too often, over the last 5 years, we have focused singularly on the issue of a willing patient, not unimportant, very important, to the exclusion of a willing physician, notwithstanding charter rights of those physicians that are very much at play. Now, in the Carter decision, Madam Speaker, the Supreme Court did expressly acknowledge the rights of healthcare professionals in terms of freedom of religion and freedom of conscience. But the court actually went further. The court warned against compelling healthcare professionals to provide or otherwise participate in MAID. More specifically, Madam Speaker, at paragraph 132 of the Carter decision, the court said, quote, "However, we note in addressing the topic of physician participation that a physician's decision to participate in assisted dying is a matter of conscience and in some cases religious belief," close quote. Now, the foundational principles that underlie freedom of religion and freedom of conscience guaranteed under paragraph 2A of the Charter were set out in the Big M Drug Mart Limited decision. And in enunciating those principles, this is what the Supreme Court had to say. Quote, "Freedom can primarily be characterized by the absence of coercion or constraint. If a person is compelled by the state or the will of another to a course of action or inaction which he would not otherwise have chosen, he is not acting of his own volition, and he cannot be said to be truly free." The court went on to say coercion includes indirect forms of control which determine or limit alternative courses of conduct available to others. Madam Speaker, that is precisely the principles that this bill seeks to uphold, and on that basis, I urge its passage.